One of the most surprising turns was your transfer. How did you navigate those challenging times? Because we also heard that you thought of resigning, but some seniors told you not to take an extreme step like that.
It was not an easy period. So there was a certain amount of mental turmoil for a little while. But when I discussed the issue with my family and my peers and seniors, I realized that I could perform the same function and do the same job with the same verve and vigor as I did in Delhi. So it made, at the end of the day, little difference.
The recent debate across the nation has been, where does one draw the line when it comes to comedy and freedom of expression? And it's essentially become comedy versus vulgarity.
So I think humor is good. The problem is when it sort of becomes black humor or humor that is insensitive to certain situations, which people think is crass.
Do you think somewhere that mard ko dard nahi hota kind of a stigma holds people back?
I don't buy this that men are stronger. Women are much stronger, both mentally and otherwise.
When everything is a click away with you, would you think OTT regulations would better the situation, would help in regulating it adequately, or would it actually lead to excess censorship?
I don't believe that states should regulate OTTs. There is always this fear of over-regulation where it may cut down artistic freedom, it may cut down freedom of speech and expression.
Do you somewhere feel that judges, because of these punitive transfers, it affects their decision making?
If you're clear about what your job requires, why should it affect you? As I said, it's the best job in the world because no one can tell you how to do your job. Even the Chief Justice of the court can't tell you how to do your job. It is when you decide to get pressured is when the problem arises.
If you have fire in your belly, you can unshackle the entrenched system. These words of wisdom by Justice Rajiv Shakdher have not only been words which he has preached, but also practiced. Dear viewers, I'm Anmol Bawa, and welcome to this segment of Live Law, where we will get to know more about Justice Shakdher. Justice Shakdher was elevated to the Delhi High Court after practicing at the bar for 2 decades. He was transferred to the Madras High Court in 2016 and transferred back to the Delhi High Court in 2018. Justice Shakdher was appointed as the 29th Chief Justice of Himachal Pradesh High Court and retired on October 2024. Welcome, sir, and we're grateful to have you here.
Thank you so much, Anmol, for having me over.
So, my first question is that even before you joined the bar, even before you joined the bench, you had a very flourishing career as a lawyer. And you were a very sought-after professional. After all these years of being as a judge since 2008, you have come back to the profession. How does it feel like?
Oh, it's wonderful. I mean, getting back to the bar is a experience which most judges vie for. It depends where you end up. Since I ended up at the High Court as a Chief Justice of Himachal Pradesh, I had the option of going back to the bar, and I have no regrets. So, yeah, the experience was good, and I'm enjoying it.
So, we've often seen that practitioners are reluctant to take up judgeship because of various reasons. Have you ever repented on taking up judgeship or no?
Well, there are several reasons why an individual would decline judgeship. So I've always said that if an offer is made and not sought by an individual, he should accept it because I would believe that when a senior judge or the Chief Justice of the concerned court asks a lawyer to join the bench, he would have, or they would have, analyzed his suitability, his eligibility with regard to the job at hand. It is, in a sense, a confidence that the bench expresses in an individual. So, I think an individual should accept it, save and accept when they have certain other personal limitations, which could be, from young children, financial liabilities, etc. But net, if all things are equal, and if you want to do a job, it's the best job in the world, because you're your own master, at least within the four corners of your court. You can paint a wide canvas, and no one can tell you how to do your job. So, what more would you want in a job?
So, as in your journey as a judge, one of the most surprising turns was your transfer to the Madras High Court. And at that time, LiveLaw also covered that it was widely said that Delhi's loss is Madras's gain. Such is the affection that the Delhi bar had towards you. And thereafter, you were transferred for almost 2 years. How did you navigate those challenging times? Because we also heard that you thought of resigning, but some seniors told you not to take an extreme step like that.
I've said this before. Uh, it was not an easy period. Uh, so there was a certain amount of mental turmoil for a little while. But when I discussed the issue with my family and my peers and seniors, I realized that I could perform the same function and do the same job with the same verve and vigor as I did in Delhi. So it made, at the end of the day, little difference to me personally where I was located. I would get almost the same wherewithal, give or take some bits, to function as a judge. So I decided to move on. And over the period from then to now, I think it was a good decision. You're right, LiveLaw was the first one to coin that phrase for me. I was surprised, but they did. Interestingly, when I was asked to move back to Delhi, the Madras bar, and especially the senior bar, when they gave me a send off, they reversed it by saying it is now loss for Madras and gain for Delhi. So, as an individual, that was a good takeaway for me. I couldn't have asked for a better send off.
And should there be more transparency in the procedure for transferring High Court judges?
Well, administratively, they say that yes, it is the prerogative of the collegium in the Supreme Court. And more often than not, they say in the transfer order that this is being done for administrative reasons. But I do feel that it would be a good idea to speak with the individual concerned, because at an individual level there may be disruption. You could have a sick parent, you could have small children, as I said, and conversation, in my view, never hurts, because especially when you're talking about judges at the level of the High Court, in their own right, when they come and join the bench, they would have done at least 18 to 20 years of serious practice at the bar. They are mature individuals. If they are explained what are the reasons, it would help the system. If it is a positive transfer, and I have always mooted this idea, it is good for the system, because there is, as I call it, cross-pollination. If the Delhi High Court has judges with some strengths, they could go to another High Court where they need a little beefing up. And similarly, from the other High Court, people could come to the Delhi High Court. I'm just giving an example of, say, Delhi and Madras. But it could be done vis-a-vis Bombay, Delhi, Chhattisgarh, Rajasthan, so on and so forth. So if you do it with those reasons to strengthen a jurisdiction, or in a very broad sense help judges in other courts, or have them mentored by senior judges who, for example, do commercial work in Delhi, so that you could have that kind of strength in another court. Coupled with some kind of assurance, if the judge wants to return to his parent court, that he would be called back after a particular point of time. So if this kind of a transfer policy is forged, I don't think there will be very many individuals, unless they have their own personal difficulties, who would say no to it. It allows you to see another part of the country. It allows you to meld in another part of the country. Personally, I was enriched when I went to Madras as an individual. I saw another culture to which I was not as deeply exposed as I did when I went there as a judge. And I'm not only talking about what happened within the court precincts, but outside. Tamil Nadu is a very rich country in terms of culture, architecture, etc., etc. So that's my view on the matter, but it's for someone else to take the decision.
So you mentioned about how such transfer of judges is very important, like cross-pollination. In the same address, you also said that, but the transfers are not being done the way they should, and they are being seen as punitive transfers. So while your experience was very enriching and you took it in your stride, do you somewhere feel that judges, because of these punitive transfers, it affects their decision making? It influences their decision making, or in a way pressurizes them?
No, I don't think so. Anmol, it is very individual centric. I can only speak for myself. Did it affect my performance as a judge? I don't think so, though the bar would be in a better position to evaluate me and my functioning both as a judge in Delhi High Court and Madras High Court. If you're clear about what your job requires, why should it affect you? As I said, it's the best job in the world because no one can tell you how to do your job. Even the Chief Justice of the court can't tell you how to do your job. It is when you decide to get pressured is when the problem arises. Just because you've been moved doesn't mean that you have to get pressured. You do what you want to do and the way you want to do it in the four corners of law. I don't think so.
So you've been in the profession for almost 30 plus years. And what are the key qualitative changes that you see within the profession now that wasn't there back then when you joined? How has the profession flourished for the better, or is it the other way around?
No, there is certainly an exponential growth, both in numbers, insofar as lawyers are concerned, as well as cases, the kind of cases that we are doing, the jurisdictions that we are dealing with, because technology is playing a great part. So therefore, you have issues with regard to technology, you have issues with regard to intellectual property rights, dealing with technology, and various other facets. So, in that sense, there has been an expansion and growth. If you're asking me, is there any change in the way the courts function or the bars function? According to me, the change, if at all, is brought about by numbers. The pressure on the courts has increased in terms of the volume of work. How you would navigate that is really a policy decision of those who are manning the court. It has to be an interactive process. The bench has to take into account the views of the lawyers in this for a smooth functioning of the institution. So broadly, it remains the same, but with changes that I just told you.
That's quite an interesting point you made, sir, that the bench and the bar have to be in constant dialogue for the betterment of the profession. When we talk about the young entrants in the profession, not only just young lawyers, but also those who are still interning, we often come across stories where there's the hard work of the interns and the young lawyers is not adequately recognized. It's not adequately dealt with when it comes to remuneration, or when it comes to even giving them some a balanced work-life condition, because the profession can be very stressful. Do you feel that what do you feel would be the practical measures that the bar and the bench together can take towards this?
See, one of the things that is being stressed upon these days is about paying some remuneration to young lawyers and interns. Insofar as interns are concerned, if they're attached to judges, every court is paying them a minimum amount. It varies from state to state because they are dependent on funds of the state government. For example, I'm told in Delhi now we are paying about 65,000 rupees a month to a law researcher. So the expression law intern that I use may not be correct, because intern really comes for 3 weeks, 4 weeks. So they don't get anything. But the law researchers do. So these are young lawyers. But when they are with lawyers as against judges, then the field is unregulated. Depending on who you are, some seniors pay, some don't pay. There is a case for the bar associations across country to evolve some criteria for paying, young lawyers who join the profession, because you may be in city A and you may be resident of another city, and therefore paying for boarding, lodging may be difficult if you don't get anything. In good old days, seniors didn't pay anything, by the way. Why? Because they thought it was a privilege to gain entry into a chamber. Especially the more seasoned senior lawyers. I believe some seniors in some states still hold this view, which is impractical, because you need to, help them with these minimum expenses: transport, boarding, lodging, etc. So this is something that bar associations should delve upon. In fact, the Bar Council of India could also think about ways and means how some guideline or some regulation can be put in place, so that young lawyers, depending on the number of years of their experience, will get a base amount. After that, if a lawyer wants to pay him or her over and above that base figure, it would be the call of that particular individual. But yes, they should be paid.
So, when we talk about these young professionals, one of the most overlooked section within this set of professionals are the differently abled lawyers. And you have in the past been vocal about the need to include them within the profession. What do you think would be the effective measures to have that kind of inclusion? Is it just infrastructural support, or the mindset really has to change of the senior lawyers or of the bench, that how what would be the practical ways to include these?
Something similar to what I just said. These young lawyers, whether they're researchers or otherwise, need to be absorbed. So I think there should be a policy formulation in every court that when you absorb law researchers, a certain percentage of differently abled lawyers should also gain entry. That is not happening really. It's again dependent on how each judge thinks. So when I was moving to Shimla, I remember there's this young lawyer who's differently able who came to me, and he wanted to work in my chamber, and I engaged him because the period was short, and I was then on my way to Shimla, or at least there was that conversation. and it didn't. He couldn't stay longer than I would have wanted him to. But what I did instead was, and something that I need to underscore because I'm getting an opportunity today, is that uh, while you may make reasonable accommodation, that's the principle that applies in this area, for differently able lawyers in terms of infrastructure, in terms of IT infrastructure, etc. You need to provide them work. See, as a professional, if you don't have work, uh, you'll not be able to hone your skills, you'll not grow as a lawyer. Along with that, you need to provide them money for that work. So, one of the initiatives that we took at the Delhi High Court, since I was heading the Delhi Legal Services Committee, was with the help of my secretary, the then secretary, Mr. Arul Varma, who was a judicial officer. We absorbed differently able lawyers on the panel for legal aid work. So while they got work, they also got some bit of money. The experience was very satisfying because I remember one of those lawyers, um, Mr. Arvind, who was wheelchair born and had difficulty in speech, was ecstatic when we sort of put him on the panel, because see, you may have disability in terms of not being able to move or speech impairment, but your mind is all there. So we put him on a job where he would render opinions to litigants. He was, very happy that he got such an opportunity. So these are ways and means by which you can actually empower them. They're not looking for sympathy, Anmol. They're actually looking for being put at par with individuals who don't have these kind of handicaps. You could appoint them as amicus in courts. You have matters dealing with litigants who are differently able. I did that in one matter where there was an issue concerning transfer of a differently abled person. That differently able person had a private lawyer for himself, but I decided to engage another lawyer uh, who in his own right was brilliant, who's gone to Harvard, etc., Mr. Rahul Bajaj, as an amicus, only because I thought I needed a better perspective about what a differently able litigant undergoes if he is put under threat of transfer. It's difficult to understand for someone who's uh, you know not burdened with these handicaps, as against one who's actually experienced it. So the perspective changes. Not that the private lawyer wasn't doing a good job, that person was doing a brilliant job, but I needed another perspective for myself. So I engaged. Now, two things happened with that experience. When that lawyer got up, apart from the perspective he gave me about the matter, he got exposure. People saw him arguing, and there were several litigants in court who would have realized that he argues as well as someone who doesn't have these handicaps. So next time around, maybe he'll get engaged. So this is the way you give them visibility. They don't want to be hidden in some corner and given some doles. They want to be there with you on the same stage as one who doesn't have these handicaps. So that's how I would go about, doing this piece of work if it was handled, if it was to be handled by me then as a judge or outside now, to find them work.
So, as a judge of the Delhi High Court, you were known to be both hardworking and pleasant. How did you ensure that that work-life balance is maintained and you did not let the work in a way influence or really reach your stress levels per se.
Well, I'm sure others have their own model. If I was pleasant, that's a matter of perception. If the bar felt that I was pleasant, uh, they're kind. They sometimes don't have such kind words to say about a judge, especially when one of them loses the matter. Uh, as far as hard work is concerned, I don't think there is a choice with judges who want to work in today's time and space, because there is so much caseload that if you have to do justice to the pay and perks that we get, you need to work from 10:30 to 4:30 or even beyond, which is what I used to do. Sometimes I did get flack for that from some members of the bar because they were made to sit late in court. But yeah, I am actually of the view that just because as a judge you have caseload, you can't sort of expose your irritation or sort of the difficulties that you're facing in navigating there for everyone to see, because for that lawyer for who's before you and the litigant who's before you in that particular case, it is his only case perhaps for the day, if not for the month. So he expects a certain amount of room to argue. I've often seen, you know, at times some people say that, we've understood everything, we've read everything, and therefore we have the answer. That model somehow didn't appeal to me. As an adjudicator, as a judge, you must give yourself time and space to hear the lawyer, in fact, both lawyers, and then come to a view one way or the other. Because often when you're hearing people uh, uh, and you process it the way you're supposed to, you could come to a different conclusion. But that was my model, but everyone, I'm sure, has his own model.
So you mentioned about the importance of hearing out a lawyer properly to arrive at a informed decision. Now, so we often see that lawyers complain that, while matters are dismissed or matters are decided with a very short hearing, while on the other hand, senior advocates are given hours and hours to argue. Do you think that somewhere we are moving towards the model practiced by the USA Supreme Court where arguments are shorter and written submissions are longer?
Well, I don't think there's anything wrong with that model, but that has then to be applied across the board. If you are going to say that the court hearing should be according to the time slots that you give them, followed by submissions or preceded by submissions, that's a good idea, uh, especially the caseload that we have. But then it should be applied across the board. It shouldn't be, as you say, senior dependent and someone who's not so senior or a middling senior or whatever. That said, when you slot time, also as an adjudicator, I think you must sit back and hear, not just listen. In the sense that you should give them space. If you've given them half an hour, it can't be in half an hour for 25 minutes. If I was the judge, I'm speaking, and for 5 minutes that other fellow was speaking, then he wouldn't have his half an hour. So, nothing wrong with what you just said, if they move to that. But then it should be uniform.
You also mentioned about how you had a habit of working till late in your High Court chamber, and then you got a flack also for that. So we also see criticism from the public also about court vacations, and that judges take these vacations and they are not working in these vacations, but in fact, the reality is that be it a Supreme Court judge or be it a High Court judge or even a judge in the lower judiciary, they all utilize that time to write the pending judgments, to ponder upon the pending issues of law, majority of them. So, would you like to dispel this notion that on the criticism of court vacations?
First of all, when I said flack, I said it in a lighter way. I mean, someone would tell me that since you sat late, one retired colleague told me when I was in harness that because you sat late, my arbitration got delayed. To which I didn't have an answer because I was trying to do what I thought was before me, and I didn't know that particular person had to go for arbitration. And my rule was always this: that after uh, the allotted time, the court would rise at 4:30. Uh, if both lawyers were okay, then we continued. If one lawyer said I can't, then obviously we wouldn't continue with the hearing. This is something that needs to be spoken of, discussed at various, or rather on various platforms, so that the public become aware of the fact that vacations are not purely vacations. Judges utilize that time for writing. That said, judges also need to, recoup their mental health. The job involves a lot of stress. So if you don't take vacation, you will have no work-life balance. They have families, they have children. Most of them, during their stint as a judge, really ignore that side of their family life, because if you come into court, say at 10:30 or earlier, depending on how you work from home or in court, and you go back, say about 8:30, 9 o'clock, and then again after you had your dinner
There's
or
a
whatever.
constant burnout.
Yeah, so they need that break. Otherwise, there'll be a complete collapse. So I don't buy this that these vacations should be truncated beyond what is reasonable. In fact, they shouldn't be truncated. I don't think they are unreasonable. The other most important thing that people forget is that this system works on the basis of lawyers being available and judges being there to adjudicate upon disputes. Now, for instance, if we were to agree with people who say that there should be no vacations, which means the court would work 365 days of a year, except for the weekends if you score them out. If you don't score out the weekends also and you say it's a utility service, it should work 24/7, 365 days of the year, you won't have the lawyers, because lawyers also need a break. They have a family. And a lawyer could have his matter in 5 different courts. And this system would work only if judges were given some amount of leave based on their unavailability for a particular period. Say suppose a judge goes off for a week or 10 days and tells the chief, I'm not available in this period. And the lawyer may have his matter not only before the judge who decides to take leave, say for 2 weeks, but may have his matters in another court where the judge is functioning. So in any event, the lawyer cannot take off because he has matters in other courts. So one judge is on leave, the other one is working, or the third one is also working. So how does it work? It can't work like this. The problem that we have about caseload is not necessarily because of vacations. It's because of other systemic problems and issues which need to be worked at.
So you mentioned about systemic problems. One of the pressing topics of discussion recently has been appointment of judges. What, according to you, would be a more practical and a suitable measure to ensure that honest and good talent is recommended and elevated to the bench?
See, when you pick up a person for appointment as a judge, uh, a lot goes into that exercise. In the sense, you look at his performance in court. You also ask people about his background, and there are checks and balances. Even when you recommend a name, as we all know, they are subjected to IB scrutiny, etc. Then it goes from High Court to the next level, which is the Supreme Court Collegium. The uh, process is all right. It is about perhaps pushing and pulling between two wings of the state. The state presently feels that it should have a stake in appointment. The lay of the land is that once a recommendation is made by the collegium, the Supreme Court Collegium, they can give their feedback. It will go back to the Supreme Court Collegium, and if they sort of reaffirm their position, then that has to be accepted. Now, I'm not saying anything new. If that is presently the law, then this entire process should happen very quickly. Some timelines need to be fixed between the time you ask for a person's consent for appointment. The process, the next step, which is sending the name from the High Court to the Supreme Court, should be within a particular time frame. Then the Supreme Court Collegium considering it also should be within a particular time frame. In between, when you have the IB input, etc., some timeline should be fixed. The trouble today is that even when a recommendation is made, uh, there is no defined time frame within which the appointment will come through. With the result, a person could wait for 2 years or more, as it has happened in some cases, without getting appointed. He or she actually loses a lot of face, and resultantly, a lot of people lose faith. They don't give consent because they think, if my name is going to be floated like this for 2 and 3 years, why should I give consent for appointment? So therefore, good lawyers who are earning good money in the profession seem to have now taken the view it's better to be on this side, earn your fee and go home. Why expose yourself to all this? Because you see, what happens is that the rumor mills start churning as to why his name is not, or her name is not going through. May not be true at all, but that's what an individual is exposed to. I don't think that is fair.
That's quite an interesting point you made, sir. You said that because of a lack of any fixed timeline to approve these recommendations, lawyers are actually getting discouraged to really opt for such kind of positions. Another aspect of this that we have heard recently is that, and as you mentioned, that now the executive also seems to be wanting to have a stake or a say in who should be recommended and who shouldn't be recommended. There have been talks that there have been informal systems in place where the government would informally beforehand approve certain names, and then the official collegium system of recommendations would start. So, how true is this? What is your take on this?
You see, Anmol, I can only say from my experience, as far as I was concerned, I was part of the collegium in the Delhi High Court. No one approached me, but I was not the Chief Justice of the court. I was a member of the college. Now, if this is happening at an informal level, and I have to say yes or no, someone who was exposed to it should say it. What you have heard, I have also heard, but that actually shouldn't make much of a difference. Why? Because uh, even if the executive were to communicate something informally, uh, the collegium has the last word on it. The collegium uh, could take that into consideration in the sense, you know, if they flag something about an individual, it could be handled in very many ways, which is either the collegium would say that please give us the relevant material, put it down on paper, or make their own inquiries. Because, as I said, the system, both at the High Court and the Supreme Court level, is that judges do informally ask people, even members of the bar, through their own colleagues, about someone's background, his ability to uh, discharge functions as a judge, etc.
But then that's judges.
No, the judges perhaps informally ask the members of the bar, senior members of the bar. I have known chief justices who, when they're appointed and they go to a different state, because you have chief justices from different state, from the one you are manning, then he wouldn't know what is the local lay of the land. Uh, he would necessarily have to ask his colleagues or some senior members of the bar who would appear before him to find out as to how suitable a particular candidate is. So that even judges do informally before they send names. That is well known. Now, if in the process someone from the executive were to say something to you, you can always hear it and do what you think is right. The problem is, uh, there is a certain amount of time lag in all this. If you keep it tight, insofar as time frames are concerned, you would say the yes or no very quickly. One. Two, it's always, especially when the executive is concerned, you could always tell them, that I have done my background check. I think the candidate is okay. But if you are saying there is something wrong, please send us the material. We'll have a look at it. Now, the proper channel will, of course, be the Ministry of Law, because that's the ministry which interfaces with the college. Uh, as I said, these are checks and balances that can work, but if they are not working, I think there is sometimes a little bit of miscommunication. They don't talk, and then each one is in their own zone, and that's why the candidate suffers in the process. So, yeah, there's scope for improvement. You're right, absolutely.
So you were the Chief Justice of the Himachal Pradesh High Court, and you had a sizable career span as a judge in the Delhi High Court. How were the two bars and how were the two courts different? Were they different in their approach? How would you say that?
See, Himachal is a mid-sized court, so is Delhi. The difference between the two is that the Delhi High Court deals with several jurisdictions. So, insofar as the lawyers here are concerned, they have a distinct advantage because they can appear in tribunals like the NCLT, the NCLAT, the Competition Commission, the appellate, and other appellate tribunals like the National Consumer Disputes Redressal Forum, etc. Then, of course, you also have the Supreme Court. So, the bar in Delhi has an opportunity of being exposed to a whole set of areas dealing with law. Himachal, of course, doesn't have that advantage. I'm told it's getting there fast, especially in the field of IPR. I was told by a very seasoned IPR lawyer that a lot of IPR matters are now being filed there. I guess it will take a little time, but uh, as far as lawyers are concerned, uh, they are the same in the sense. At least I didn't have any problems in Himachal, although my stay and stint was very short. But I was able to connect with the bar very quickly. They had some issues which I attempted to solve, including designations. I was able to, you know, go through this designation process very quickly with the able assistance and help from my colleagues who were very, very cooperative. And we were able to designate people. Likewise, as far as district judges were concerned, they had issues and outstanding problems, which one was able to solve by, you know, interacting with them, talking to them. So it's about the kind of work that is available that helps mature a court. If you get good commercial work to Himachal Pradesh, certainly the, you know, the exposure of the lawyers would accordingly scale up. That apart, it's the same.
So we know that you have a forte for arbitration. And arbitration, whenever we think of arbitration, we think of efficient or a speedy justice delivery mechanism, so to say. Recently, the central government has issued a certain circular discouraging against the arbitration as a mode of dispute resolution, whereas judges, on the other hand, have openly advocated for arbitration as an effective ADR mechanism. What do you think would be the reasoning for such a circular by the union?
Anmol, that is a question that you must put to a government representative as to why they would issue such a directive. If you are advocating alternate dispute resolution everywhere, then arbitration is certainly one of those modes. Why would you not encourage it by even calling upon PSUs and other public utilities to have these clauses in their agreements? So there is a little bit of dissonance between what is said on the world stage that we want to encourage alternate dispute resolution, which includes arbitration and mediation, as also conciliation. And on the other hand, you have these directives. Not good news for the arbitration bar. The government needs to, revisit this and perhaps think of other ways and means. If there are any problems in the arbitration concerning public utilities, what could be done? This is like throwing the baby with the bathwater. If there are problems, they should discuss it at forums so that they can be sorted out by the bar and other stakeholders.
So you've amply talked about mental health issues and how it's important to recognize them and to, in a way, emotionally vent out when a person is feeling lower, is feeling frustrated about things. It's important that the emotional expression should come across. When we talk about the legal profession and addressing the issue of mental health within the profession, what is it that's holding us legal professionals back? And also the fact that, the legal profession, unfortunately, fortunately, has been largely male dominated throughout years. Do you think somewhere that mard ko dard nahi hota kind of a stigma holds people back from within the profession from speaking up?
See, mental health is an issue not only with people in our profession but in other professions also. By and large, when you look around, you'll find that in India there are not many experts, psychologists or psychiatrists to deal with these issues. There is stigma in our country even now about mental health issues because people generally go away with the impression that if you're going to a psychologist or a psychiatrist that you've lost it, which is not true. In other parts of the world, it is very common for people to seek assistance of a psychologist or a psychiatrist whenever they go through issues which they can't deal with, which could be marital, which could be loss of a child, parent, loss of a job, breaking up where young couples are concerned, how to deal with your lives thereafter, etc., etc. So, so is the case with professionals when you're not growing and your liabilities are increasing in the sense that you get married, you're not bringing enough by way of money to your house, you have a family which is dependent on your earnings, etc., etc. Now, should the court as an institution vis-a-vis our profession do something? I think certainly there's no harm in having mental health specialists in courts where lawyers can freely go and discuss their issues after taking appointments, etc. The court could tie up with some institution, specialized institution as well. So these are aspects which every Chief Justice can look at to help young professionals, even older ones or those who are middling, so that they could, access such service. You are also right to the extent that the number of women lawyers has been traditionally less. But that perhaps is changing, especially in metropolitan cities. There are more young women who are coming into the profession, both as judges and lawyers. In fact, in the district courts today, the percentage of women judges is pretty healthy. So this would perhaps change, say, in another 5 years, if not more. You'll see the profile of the bench changing. And when the profile of the district court changes, and maybe those who come up to the high court and to the next court, that would also change. So you need to give it a little time. But I don't buy this that men are stronger, the phrase that you used just now.
मर्द को दर्द नहीं होता.
I think that's a Bollywood expression which I don't subscribe to. I think if you ask me, women are much stronger, both mentally and otherwise. They are able to multitask. Men sometimes have a tunnel vision. If they pick up something, they would only concentrate on that. Whereas women, they can do their profession, they can tend to the family, they can, which is sometimes not fair. They're supposed to cook, drive, take the child to school, and attend court as well. But with young couples, I guess it's changing now. They want their partners to pitch in. And some are doing it. I have colleagues who do this. I also know of my ex-colleagues as judges who very actively pitch in. They look after the child at home whenever that colleague had leave available to him, and the wife, who was a professional, would go and do her work, including travel. So that's changing, perhaps more in metropolitan cities and less in other places. But this is where technology helps. When people see others doing it, they also do the same thing.
So you mentioned about how technology has helped in so many ways. For instance, women empowerment within law. When we talk about technology and exposure to technology, the recent debate across the nation has been, where does one draw the line when it comes to comedy and freedom of expression? And it's essentially become comedy versus vulgarity. In one of your past speeches, you mentioned about how something that is vulgar may not always be obscene. And in India, there's a certain community standards test that is applied when we have to determine obscenity. With this ongoing heated debate about where to draw the line, and where creators, writers, comedians, actors, and even politicians are saying that we have a freedom of speech and expression. What is your take on this? Where do we actually draw the line?
See, I thought this is a question that Anmol, you would ask yourself, because you come from an age bracket which fits in with all this. It's the youngsters who are pushing the boundaries, correct? And they feel that all this very sanitized comedy is not good for them. They go for these comedy shows. I like comedy shows. In fact, I don't know whether you're aware of this. I was instrumental, let's say, in having a web page on the Delhi High Court website about humor in court. So I think humor is good. The problem is when it sort of becomes black humor, or humor that is insensitive to certain situations, uh, which people think is crass, and therefore that's an area you shouldn't allow them to go to. The uh, comment that you just attributed to me about vulgarity and obscenity was in an interview, not even an interview. I think I was at a book release
Yeah.
of an author on obscenity. And we were discussing it in the context of penal consequences for obscenity. And I did say that something that may be vulgar is not obscene and doesn't generally come within the uh, penal framework of the Indian law. There are several judgments of the Supreme Court which take the same line, that for it to be obscene within the meaning of criminal law, the tests are different. The community standards keep changing, correct? So it was said in that context. In fact, a very recent judgment of the Supreme Court said the same thing. This was a serial about, if I'm not mistaken, I have not seen the serial, but I read broadly about it, about some youngsters, and they used foul language in that serial, which was deprecated by the High Court, but the Supreme Court took a contrary view on the matter, because it needs to be contextualized. When you see a film or even a live play, you need to contextualize it. If in the context it fits, then perhaps it will pass the test of not being obscene. So the recent incident that you're talking about is something that the Supreme Court was grappling with. It perhaps, according to the court, crossed that Rubicon, which it ought not to have crossed. It does become to a certain extent subjective. At the end of the day, all judges are human beings. They have their, which is the obvious thing that I'm saying, but with technology, it may not be human beings, it may be robots. But as we are presently positioned, there is a certain amount of subjectivity which comes with the kind of circumstances you've been exposed to. So the law keeps changing. I mean, one set of judges may say this much is all right. The other set of judges may say no, you need to narrow it. It's an evolving area.
That's quite crucial a point that you made, sir, that the law will become subjective over here. And when we're talking about freedom of expression, art, and artistic expression, we're also talking about technology, and we're also talking about OTT. So to say, the YouTube content that we have, the Instagram content that we have. And this is different from the cinema, where we have a film certification board and regulations in place to censor or not to certify a certain film. when everything is a click away with you, would you think OTT regulations would better the situation, would help in regulating it adequately, or would it actually lead to excess censorship in a way?
See, Anmol, I don't believe that state should regulate OTTs. Self-regulation by way of guidelines, etc., is all right. Then there is always this fear of uh, over-regulation, where it may cut down artistic freedom, it may cut down freedom of speech and expression. So, state intervening in the matter is something that I am very wary of. You already have a set of guidelines which may be not appropriate for the community standards in A country as against B country. They could always be tweaked. But state regulation is something which is bad news. So that needs to be avoided, which is my view in the matter.
So, as we reach the end of our interview, the last question that I have for you is, how would you define justice in one sentence?
Well, I can only think of what Mahatma Gandhi said, that when you talk about justice, you must look at the poorest amongst those who would be affected, and then see how it would impact that person. I've said this quite often, both when I was a judge and now to my friends, that unless law and justice coalesce, the litigant always feels that the result is not fair. So that's the test for me.
Thank you so much, sir. Thank you so much for taking our time for us and expressing your views and your experiences openly.
Thank you. Thank you, Anmol. As I said, having me over here.
Dear viewers, I hope our segment did some justice to your precious time. Thank you so much for watching. Do like, share, comment, and subscribe to our YouTube channel. Thank you.